Good morning, and welcome to this privilege update presentation hosted by BCL Legal. My name is James Quinn, and I'm a director in the dispute resolution team at Boyes Turner Solicitors in Reading. In my presentation this morning, I will run through 4 important commercial court and Court of Appeal cases from 2020, in which rulings have been given on different aspects of the law of privilege. In the first case, judicial review proceedings involving the airline Jet2 and the Civil Aviation Authority, the Commercial Court and Court of Appeal clarified the test for establishing legal advice privilege. This case focused on communications between the Civil Aviation Authority's commercial executives and its in-house legal team. The Court of Appeal provided helpful illustrations of scenarios in which in-house counsel may sometimes find themselves and whether or not their communications will be covered by legal advice privilege. The second case is also a judicial review case, this time involving Sports Direct and the Financial Reporting Council. This case focused on the question of legal advice privilege in the context of regulatory proceedings. The third case, which we will then go through, concerns the issue of waiver of privilege. This is in the context of civil proceedings, which followed on from high-profile criminal prosecutions brought by the Serious Fraud Office against Barclays Bank and a number of its senior executives, arising out of the 2008 financial crisis. And lastly, we will consider an interesting judgment of the Commercial Court from September this year, in which the court was asked to decide whether communications between a Russian company and its internal legal team were protected by legal advice privilege in the English High Court proceedings. And I'll talk for about 40 minutes or so, and then there will be time at the end for some questions. So if you'd like to raise a question, please use the raise your hand facility, and my colleague Kerry will facilitate that. So first then, let's look at the Jet2 CAA Court of Appeal decision, which was handed down in January this year. This is an important decision in which the Court of Appeal has clarified the test for establishing legal advice privilege, and is possibly the most significant case on privilege this year, I think. The decision also provides helpful practical guidance on the applicability of legal advice privilege, the emails sent to certain types of recipients and combinations of recipients, in which we'll come on to look at. So, to start with the facts of the case, the Civil Aviation Authority was promoting a new ADR scheme for the resolution of consumer complaints against airlines. It wanted to replace an existing voluntary ADR scheme with its new ADR scheme, and with all our airlines to participate in it. Most of the UK airlines had signed up to the new scheme, but not Jet2, which was continuing with the old mediation service funded by the CAA. In December 2017, the CAA issued a policy document on its new ADR scheme. At the same time, the CAA issued a press release in which it criticised Jet2 for not joining up to the scheme. This included a quote from the CAA's CEO, Andrew Haynes, criticising Jet2's refusal to sign up to the scheme and suggesting that Jet2's customers were being put to a distinct disadvantage by not having access to the CAA's new ADR service. This led to a letter of complaint in January 2018 from Jet2's CEO to Mr. Haynes, and he explained why Jet2 had not signed up, and Jet2 issued its own press release. Later, in January 2018, the head of the CAA's Consumer Enforcement Department emailed a draft letter of response to Mr. Haynes and others at the CAA, including a principal legal advisor in its in-house legal team. On the 1st of February 2018, the CAA sent its letter of response to Jet2, repeating its earlier criticisms of Jet2. The CAA also took a step of sending the correspondence with Jet2 to the Daily Mail, which then ran a story on the issue. In April 2018, Jet2 began judicial review proceedings, challenging the CAA's decision to publish its press release and correspondence with Jet2. The grounds of the application are set out on the slide, and as you can see, include an allegation that the CAA acted for unauthorised purposes to damage Jet2's trading interest and reputation, and to pressurise Jet2 to join the scheme. In the judicial review proceedings, Jet2 made an application for specific disclosure, seeking copies of drafts of the CAA's 1st of February letter criticising Jet2, as well as the CAA's records of discussions about the drafts. This was said to be relevant to Jet2's improper purposes ground of challenge. In response, the CAA's principal legal advisor confirmed the existence of drafts and records of discussions of the drafts. The advisor confirmed that she and another in-house lawyer had discussed the drafts and given advice on them, and did not waive privilege in the advice. In the High Court, giving its decision on the High Court gave its decision on the specific disclosure application in December 2018. It found that the CAA's in-house legal team had been involved as lawyers and not as members of the in-house team giving commercial advice. The court held that a claim for legal advice privilege is subject to a dominant purpose test, that is, and as we see in the quote, whether the communication or document was brought into existence with a dominant purpose of it or its contents being used to obtain legal advice. The judge found that the majority of the emails and attachments should be disclosed as they had not been prepared for the dominant purpose of giving or obtaining legal advice. The CAA appealed the decision to the Court of Appeal on a number of grounds. This included a ground that the judge was wrong to hold that the claims for legal advice privilege were subject to a dominant purpose test. It further argued that the judge had adopted the wrong approach when considering whether multi-addressee communications are protected by legal advice privilege. It was also submitted that the judge was wrong in his approach to assessing whether emails and attachments were covered by legal advice privilege. The Court of Appeal ruled that the party asserting a claim to legal advice privilege must demonstrate 1, that there is either written or oral communication, 2, between a client and a lawyer or a lawyer and his client, that it's made in confidence, and it's for the purpose of giving or obtaining legal advice. The main focus of the appeal was whether the purpose of giving or obtaining legal advice must be the dominant purpose. The Court of Appeal distinguished the Three Rivers No. 5 decision on the facts on who is the client, and it held that the CAA executives were the client from the perspective of the in-house legal team. On the subject of dominant purpose, the court found that the earlier authorities were not consistent and that the judge in the first instance decision had been correct to find that for legal advice privilege to apply, it was necessary for the withholding party to demonstrate that the dominant purpose of the document was to obtain or provide legal advice. It was noted that in the 2018 ENRC decision, the Court of Appeal's conclusion that dominant purpose did not apply was only made overturned. The Court of Appeal provided helpful practical guidance on whether legal advice privilege will apply to emails and attachments, depending on who they are addressed to. This is helpful for both in-house lawyers and private practice lawyers alike. And so let's look at the detail of this. The first scenario which the Court of Appeal set out is where there is a single multi-addressee email sent for advice or comments, including to a lawyer for their input. There, the Court of Appeal said that if the dominant purpose is to settle instructions to the lawyer, including giving advice in a commercial context as a lawyer, even if the email is sent for information only, as long as it is part of a continuum with the dominant purpose of instructing the lawyer, legal advice privilege will apply. But if the dominant purpose is to obtain commercial views of non-lawyers, privilege will not apply, even if the subsidiary purpose is simultaneously to obtain legal advice from the lawyer addressee. The response from the lawyer, if it contains legal advice, will almost certainly be privileged, even if it is copied to more than one addressee. Multi-addressee emails are to be treated as emails from the sender of the email and each recipient. And the test, the Court of Appeal said, is, would the email, if sent to a lawyer alone, be privileged? If the answer is no, then other emails are very unlikely to be privileged. If the answer is yes, the question is then whether any of the emails to the non-lawyers are privileged, for example, because its dominant purpose is to obtain instructions or disseminate legal advice. With a multi-addressee email which seeks both legal advice and non-legal advice, the email to and from a lawyer will be privileged. Otherwise, the email will not be privileged unless the dominant purpose of the email to or from a non-lawyer is to instruct the lawyer. If the communication might realistically disclose legal advice, then that communication will be privileged. Emails and attachments are to be analysed separately when working out whether privilege attaches to each of them. So, what is the position with meetings which are attended by lawyers and non-lawyers who are discussing commercial matters and where the lawyer gives legal advice as and when required? Well, the Court of Appeal said that if the dominant purpose of the meeting is to give legal advice or settle instructions to a lawyer, then unless anything is said outside a legal context, the contents of the meeting will be privileged. If, however, the dominant purpose is non-legal, the contents of the meeting will not be privileged, but any legal advice sought or given may be privileged. it is likely that where privileged or non-privileged material is not inextricably intermingled, the non-privileged content can be severable, and the privileged content can be redacted on disclosure. And so this Court of Appeal decision has provided very helpful clarification on the requirement to establish the dominant purpose of seeking or providing legal advice if legal advice privilege is going to apply. Following this decision, and as a practical matter, in-house lawyers should give thought as to whether they are acting as legal advisors or as executives when giving commercial advice in assignments and in individual communications, and whether an argument for legal advice privilege will therefore get off the ground. And as a practical matter, in-house counsel should consider whether it is possible to send separate communications distinguishing legal advice on the one hand and purely commercial advice on the other. I think it's also worthwhile considering labeling communications containing legal advice legally privileged and confidential, or a similar label. And whilst applying this label will, of course, not render the communication privileged, it may help demonstrate that the intention was to create a privileged communication, which may be helpful in any subsequent legal proceedings where there may be debate around privilege. If both legal and non-legal matters are set out in the same email and cannot be disentangled, there is a risk that the whole document may be disclosable, and so we should be aware of that. And I think the care should be taken at meetings which in-house counsel is attending. The Court of Appeal explained that the dominant purpose test applies in this situation and to a written record taken of the meeting. If the dominant purpose of the meeting is not for the obtaining or giving of legal advice, then the whole of the meeting will not be privileged. It is possible that that part of the meeting in which legal advice was requested or provided will be privileged and not disclosable if it can be disentangled from the rest of the meeting. In practice, it's perhaps worth considering during the meeting identifying that the discussion is moving on to an area of legal advice and flagging that it is privileged. This may then make the task of separating the legal aspects of the meeting from the purely commercial discussions easier, and also make the record of that meeting clearer in distinguishing between legal advice and commercial matters. So we'll move on to the second significant case in privilege this year, which is another judicial review case, and this time involving Sports Direct and the Financial Reporting Council. And in this case, the Court of Appeal considered whether privileged documents should be disclosed to an accountancy firm's regulator or whether privilege should be upheld. So looking at the facts of the case, the Financial Reporting Council was carrying out an investigation into the auditing of the financial statements of Sports Direct and its subsidiaries. It was investigating under the Statutory Auditors and Third Country Auditors Regulations 2016, or SATCAR. The FRC was concerned about the relationship between the owners of a non-group company and Sports Direct, which had not been disclosed in the group's accounts. Under SATCAR, the FRC was entitled to make a request for documents from any public interest entity, and which included Sports Direct, about the auditing of accounts. As we see on the slide, Schedule 2, subparagraph 1.8 sets out what may be requested. It provides that a notice does not require a person to provide any information or create any documents which the person would be entitled to produce in any proceedings in the High Court on the grounds of legal professional privilege. The FRC issued a notice requiring Sports Direct to provide certain emails and attachments concerning Grant Thornton's audit. However, Sports Direct withheld documents asserting that they were protected by legal advice privilege. The FRC therefore applied to the High Court for an order compelling Sports Direct to disclose those documents. The documents in question were 19 emails and 21 attachments, and the issues for the court to consider were first, whether legal advice privilege applied to the documents by virtue of having been attached to emails between Sports Direct or its subsidiaries and their lawyers. This was the communication issue. Secondly, did Sports Direct's waiver of privilege by sending copies of documents to Grant Thornton for the audit extend to the FRC? This was the waiver issue. And thirdly, would the production of the documents to the FRC infringe any privilege of Sports Direct? This was the infringement issue. On the communication issue, some of the 21 attachments were not privileged, but withheld on the grounds that they form part of lawyer-client communications. Examples of this included emails which attached a contract between a subsidiary and a third party, a draft of documents produced by lawyers for their client, and newspaper articles. In the High Court, the judge dismissed Sports Direct claim to legal advice privilege. The judge held that even if the emails were protected by legal advice privilege, some attachments were pre-existing documents and were not protected by legal advice privilege simply by being attached to privileged emails. Pre-existing documents do not become privileged just because they are given to lawyers for the purpose of advice or litigation. The judge distinguished from communications which, although they did not seek or provide legal advice, they form part of a continuum of communication between the lawyer and client in the obtaining or giving of legal advice. On the waiver issue, the judge held that there had been no waiver. He found that Sports Direct's limited waiver of privilege did not extend to the FRC. The regulatory process was separate from the audit process. It was not part of a single process, but reflected what he called fundamental separation of function and responsibility. On the infringement question, the FRC had argued that there had been no infringement of Sports Direct's privilege, as disclosures to the FRC did not result in documents becoming publicly available, and they would not be used against Sports Direct. They submitted that if there was an infringement, it was a technical infringement only, and that there was no prejudice to Sports Direct. The judge agreed with the FRC on the infringement issue. He held that the production of documents to a regulator for the purposes of a confidential investigation by the regulator into a regulated person did not infringe legal professional privilege of clients of the regulated person in relation to those documents. It followed that the same was true of the production of documents to a regulator by a client. The judge also relied on dicta of Lord Hoffman from an earlier case, creating a further exception to the absolute nature of privilege, i.e., when a regulator had power to request client privileged documents, provided only for use against a regulated person. Sports Direct appealed the infringement issue and the communication issue to the Court of Appeal. On the infringement issue, the Court of Appeal upheld Sports Direct's appeal. The court pointed out that SATCAR didn't provide for Sports Direct's privilege to be overridden. Quite the reverse, privilege was preserved under SATCAR. The court also held that there was no justification for treating the dicta of Lord Hoffman as authority for the existence of an exception to the protection given by legal professional privilege, or for the existence of some lower threshold for implying a statutory override on grounds that any infringement of Sports Direct's legal professional privilege. The court also held that the terms of SATCAR meant exactly what they say, i.e., the recipient of the notice is not required to hand over privileged documents. Lord Hoffman's comments in an earlier case did not provide a basis for saying that paragraph 1.8 of SATCAR, which we saw earlier, is qualified by the no infringement exception. On the communication issue, as we see on the slide, the court held that if the email itself is privileged, that does not confer privilege on the pre-existing document. The fact that it was sent to a legal advisor under cover of a privileged communication does not confer privilege either. The court allowed the appeal in relation to emails covered by legal advice privilege, but dismissed the appeal in relation to non-privileged attachments. The FRC asked for the Court of Appeal's permission to appeal the infringement issue to the Supreme Court, but permission was refused. Sports Direct also asked for permission to appeal on the communication point, but this too was refused. So I think this case shows certainly a very robust approach by the regulator in seeking and pursuing documents for its investigation. However, the Court of Appeal's decision and the Commercial Court's decision represent a favourable outcome for regulated entity, as the decision confirms that the privilege will apply in regulatory proceedings, whether the privilege is held by the entity being investigated or by its client. A regulated entity may decline to provide a document in response to a notice from the regulator, in this case, as we saw under SATCAR and point 1.8. The case also serves as a useful reminder that a non-privileged pre-existing document does not attract privilege simply by being sent with a later privileged communication. Moving on to our third case, concerning PCP and Barclays. This concerned an application for further disclosure. The key question for the court in this case was whether there had been a waiver of privilege in the documents which were the subject of the disclosure application, and whether the documents and further privileged documents should therefore be disclosed. The application for further disclosure was made by the claimants PCP Capital and PCP International Finance, which represented an investment consortium, including investors from Abu Dhabi, against the defendant, Barclays Bank. The case related to the 2008 financial crisis, following which Barclays needed to raise at least £6.5 billion. It raised these funds through private investors rather than government assistance. The State of Qatar and related entities offered to invest £2 billion. PCP agreed to invest £3.25 billion. PCP alleged that Barclays represented to it that PCP would get the same deal as the Qataris, which PCP says meant that PCP would receive as much pro rata by way of fees and other payments for investments as the Qataris would receive. PCP alleged that the representation was deliberately false, as in addition to expressly declared fees, the Qataris received £280 million disguised as consideration payable for advisory services from the Qataris pursuant to written advisory services agreements. PCP alleged that the advisory services were sham agreements. It maintained that no real advisory services were ever intended to be provided, and that sums payable under the agreements were wholly disproportionate. PCP also alleged that Barclays had agreed to lend the Qataris $3 billion, which almost matched the amount of the Qataris' funding, and, if used, would amount to unlawful financial assistance. The civil proceedings followed on from high-profile criminal proceedings which had been brought by the Serious Fraud Office in relation to these matters against Barclays Bank and against 4 senior executives of various divisions of the bank. The charges against Barclays were dropped in 2018, and the senior executives were later acquitted following trials and retrials. During the criminal proceedings, the SFO applied for a search warrant as part of its investigations in respect of documents over which Barclays had claimed legal professional privilege. The application was never determined, as Barclays had agreed to provide the documents under what has been described as a limited waiver of privilege. The SFO later used some of the documents under the limited waiver of privilege and referred to them in open court in cross-examining one of the defendants. In the civil proceedings, it was common ground that these documents referred to during the criminal trial lost the privilege that had previously attached to them at that point during the trial. Before these open documents were referred to in the criminal trial, some Barclays employees had been interviewed by the SFO and the FCA. Barclays disclosed those transcripts in the civil proceedings, but with redactions on the grounds of proportionality. Barclays contended that there was no basis for removing those redactions. In the civil proceedings, Barclays served witness statements from 2 of the executives who had been defendants in the criminal proceedings. It also served a witness statement from his general counsel, who had been a solicitor in the general counsel's office at the material time. The statements referred to legal advice. Barclays' written opening submissions for the trial and the civil proceedings also contained a reference to legal advice. PCP argued that by referring to legal advice in the submissions and witness statements, there had been a waiver of privilege in that legal advice. Further, as a result of that waiver, all of the otherwise privileged documents relating to the advisory services agreements were now open for inspection. Barclays made 4 key arguments in response, and these are set out on the slide. First, it argued that in applying the relevant legal principles on waiver of privilege, there had been no waiver at all. This was referred to as the basic point. Secondly, it argued that even if there had been a waiver, it would not apply, as all the references were to the open documents which PCP now had. Since the time they had been used in the criminal trial, they were non-privileged documents, and using them in the civil proceedings could not amount to a waiver. This was called the timing point. Barclays further argued that if the last 2 points didn't succeed, the scope of the documents was too wide, and this was the scope point. Lastly, it argued that the order to disclose would be unduly onerous on Barclays, being so close to trial, and this was the proportionality. So looking at the judgment, the judge, Mr. Justice Waxman, summarised the 2 key questions for applications based on a waiver of privilege. First, has there been a waiver of privilege? And secondly, if there has been a waiver, is it appropriate to order production of privileged documents other than those to which reference has been made and which was the foundation for the waiver? He commented that the concept of fairness underpins the concept of waiver, under which further privileged documents should be disclosed. That is, that the waiving party is painting only a partial picture of the relevant legal advice, and it is unfair to the other party to allow him to cherry pick in this way. Mr. Justice Waxman commented that it is not easy to find a succinct and clear definition of when waiver arises. He boiled it down to the 2 principles shown in the slide, namely 1, that the reference to the legal advice must be sufficient, and 2, the party waiving must be relying on that reference in some way to support or advance his case on an issue to be determined by the court. The judge gave 2 examples of what does not amount to a waiver, and as we see on the slide, the first is a purely narrative reference to the giving of legal advice. This is because there would be no reliance on it in relation to an issue in the case. The second is a mere reference to the fact of legal advice. As we see from the judge's example, he says, "My solicitor gave me detailed advice. The following day I entered into the contract." The judge contrasted this example with alternative wording, "I entered into the contract as a result of that legal advice." And this involves reliance on the reference to the legal advice to support his case. The judge referred to what he described as the vexed question on the law of privilege, namely that quite apart from reliance, waiver can't arise if the reference is to the effect of the legal advice as opposed to the contents of the legal advice. He referred to the Court of Appeal's decision in Marabeni and Alafousas. There, the application for disclosure was based on waiver in relation to the context of an affidavit in support of an application for permission to serve out of the jurisdiction. As we see on the slide, we see the quote from the affidavit which the applicant had seized upon for its application, and that is, "The plaintiffs have obtained outside Japanese advice, which categorically states that this agreement does not render performance of the sale contract illegal in any way whatsoever." The Court of Appeal held that there had been no waiver because the affidavit did not refer to the contents of the advice, but to the effect of it. The judge in the PCP case understood this to mean the conclusion or the result of the advice. The judge explained that the approach to determining the content versus effect distinction. This involved understanding A, whether there is any reliance on the privileged material referred to, B, what the purpose of the reliance is, and C, the particular context of the case. He emphasised that this was an acutely fact-sensitive exercise. He commented that this means that in a particular case, the fact that only the conclusion of the legal advice referred to is stated, as opposed to the detail of the contents, may not prevent there being a waiver. Turning then to the judge's findings, he referred back to one of the witness statements in which the witness stated that, as we see the quote, "I took comfort from and adhered to the lawyer's advice in these matters in relation to the advisory services agreements." The judge reached the conclusion that a waiver had occurred. First, his view was that this was more than just a reference to the fact of legal advice, and that there was also reference to the effect of the advice in referring to the conclusion of it. He also asked whether the witness was relying on the advice to that effect, and found that the witness was indeed relying on it. The judge found that the purpose of the witness's reliance was to improve the bank's case on the issues in the case concerning the advisory services agreements. The judge reached the same conclusion on other references to legal advice in other witness statements and in the bank's written opening submissions. The judge then rejected the bank's position on the timing point. His decision was that it was not the case that a once privileged document which has lost its privileged status in a criminal trial does not become irrelevant from a privileged point of view. Although the SFO had deployed the open documents in the criminal trial, the bank had given a limited waiver of privilege and would have known that the documents may be referred to during the trial. On the scope point, the judge found that considerations of fairness meant that the relevant transaction was the legal advice in relation to the advisory services agreement, and that the additional material which had been withheld on the grounds of privilege had to be disclosed. Lastly, on the proportionality point, Barclays had argued that there was a very large number of further documents to be reviewed and at significant cost, and with the beginning of the trial only a week away. The judge dismissed these concerns, finding that the cost of the document review was not disproportionate to the very substantial amount of money involved in the dispute, and that the documents did not need to be ready for day one of the trial, and so the document review exercise could be completed in good time. So I think this case is an interesting and helpful refresh on the legal principles relating to requests or formal applications for documents on the basis that there has been a waiver of privilege in legal advice. It also illustrates the difficult and very fact-sensitive nature of the analysis to be undertaken to determine whether there has been a waiver in each case. I think the judgment also serves as a helpful reminder as to the great care which will need to be taken when preparing witness statements or submissions in which you are contemplating making reference to legal advice in relation to a particular point in the case. And it will be important to ensure that you will not be taken to have fallen on the wrong side of the line and waive privilege in that advice, and potentially be required to disclose all further related legal advice. So in the last case that we'll look at this morning, involving the Russian company Tatneft, we'll look at this commercial court judgment from September, in which the court was asked to determine an application by a party seeking disclosure of communications between a Russian company's officers and employees on the one hand, and the company's in-house lawyers on the other. In this judgment, the judge provided no details on the background to the dispute or details of the issues in dispute between the parties. The only background which he considered to be relevant was the fact that the parties had given standard disclosure in the proceedings. In its disclosure statement and correspondence, the claimant company claimed legal advice privilege in correspondence and communications between officers and employees of the claimant company and members of its in-house legal department. The matter for determination by the court was an application by the second defendant for further disclosure from the claimant. It applied for an order for the disclosure of documents previously withheld on the grounds of privilege, and which comprised communication between the company's officers and employees and members of its in-house legal team. The parties agreed that English law, being the law of the country in which the proceedings had been brought, would apply to determine the question as to whether documents could be withheld from production on the grounds of privilege, and so English law principles were applied by the court. The applicant submitted Russian law evidence explaining that in-house lawyers are not treated as independent and are not members of the Russian bar, and their activities are not regulated. Their evidence was that Russian law has a concept of advocate's secrecy, which is similar to the English concept of privilege. Under Russian law, the concept of advocate's secrecy does not apply to non-advocate in-house lawyers. Therefore, since advocate secrecy does not apply to in-house lawyers who are not appropriately qualified foreign lawyers, the applicant submitted that the claimant did not have a valid claim for privilege in proceedings before the English court. In response, the claimant accepted that the members of its in-house team were not advocates under Russian law and regulations. However, they maintained that communications between the in-house lawyers and the officers and employees of the company were privileged as a matter of English law. First, it argued that English law recognises that legal advice privilege applies to advice from foreign lawyers, and that should include in-house lawyers. Secondly, it submitted that the Russian concept of advocate's secrecy was irrelevant to determining the question of privilege as a matter of English law. In her judgment, the judge upheld Tatneff's claim to legal advice privilege in communications between the company and its in-house legal team. The judge's starting point to the application was to recognise the general purpose of privilege and to recognise the general public interest in clients being able to communicate openly with their lawyers, knowing that their communications will be kept confidential and not disclosed. The judge noted that the concept of legal advice privilege in England also extended to foreign lawyers. See, for example, the 2013 Supreme Court case of Prudential and the Special Commissioner for Income Tax quoted on the slide. The applicant argued that the extension to foreign lawyers only covered those lawyers who were appropriately qualified, i.e. those who were regulated and admitted to practice. Considering the Prudential case again, the judge noted that the extension of privilege to apply to foreign lawyers by the English courts did not have regard to the national standards or regulations in force in the foreign country. Lord Neuberger suggested that this approach may be based on fairness, comity, and convenience, and he did not regard the extension to be limited to professional lawyers or lawyers qualified to a standard along the lines of, say, a solicitor or a barrister. The judge discussed the difference between the function of the relationship between the lawyer and the client rather than the formal status of the lawyer in relation to foreign lawyers. Referring again to the Prudential case, the judge noted that this functional approach was favoured by Lord Sumption, where Lord Sumption noted that although communications of a company with its in-house counsel were internal to the company, the in-house lawyer was performing the same function as the external independent lawyer, and communications with foreign lawyers have attracted the same privilege for the same reason. He summarised that the cases reflect the functional approach which English law has always taken to legal advice privilege. The applicant argued that legal advice privilege should be limited to communications with advocates on the basis that under Russian law, those lawyers who are not advocates do not benefit from advocates' secrecy. The judge favoured a broader approach outlined in the Prudential case and the grounds of fairness, comity, and convenience referred to by Lord Neuberger. She commented that it would lead to uncertainty and inconvenience if the English court had to examine the particular national standards or regulations in each case to determine if the communications between the client and lawyer were privileged. She further commented that issues of comity would be raised if the English court was obliged to express views on the qualifications and regulation of foreign lawyers. The judge noted that there were various categories of lawyer in Russia other than advocates, and to allow privilege only to apply to advocates and not to other groups of lawyers would be unfair and inconvenient. She considered that it illustrated why the English courts have not looked into the training and regulation of the foreign lawyers when considering if privilege applies. In conclusion, then, the judge held that privilege will extend to communications with foreign lawyers, whether or not they are in-house lawyers or external lawyers. The English court will not look into how or why the foreign lawyer is regulated or what standard applies to the lawyer under the local law. The only requirement is that they should be acting in the capacity or function of a lawyer. It should relate to communications between the client and the lawyers acting in their professional capacity in connection with the provision of legal advice. And there was no additional requirement for the foreign lawyers to be appropriately qualified or regulated as professional lawyers. So I think this judgment is a very helpful confirmation for all concerned that the applicability of privilege to communications with foreign lawyers extends to foreign in-house lawyers. It is also helpful to understand the approach to be taken by the English court, which will not examine the professional or regulatory status of the lawyer, but will instead look at the function of the lawyer acting in his or her capacity as a lawyer. I think this will be a welcome decision for international organisations with offices based worldwide, and where you may be dealing foreign in-house counsel who are providing advice on matters which ultimately may become before the English courts. This decision therefore ought to provide a greater degree of confidence when dealing with your overseas colleagues. I think the case also serves as a reminder for UK in-house counsel to consider whether your own advice given to overseas affiliates or subsidiaries may be potentially disclosable in potential court proceedings which may take place in the courts of that country. And depending on the nature of the transactional matter that you're working on, this is something that perhaps you should be thought to at the outset. So that completes our run through of what I think are 4 of the key cases on privilege which have come up this year. And so we'll now see if there are any questions arising from this.
Hi, James. There's been no questions, no, so you can conclude.
Very good. In which case, all I will say is thank you very much for joining this morning. I hope that you found this presentation helpful. If you have any questions after the presentation, please do get in touch and I'll be happy to answer them. But for now, enjoy the rest of your day.